Welcome back, everyone, to Keepers of Our Republic, a weekly nonpartisan podcast by the nonprofit Keep Our Republic. My name is Brooke Bergen, and I am your host this week. We are talking each week with judges and former election officials from across the United States about what it takes to keep our republic and support our democracy in these uncertain times. This week, I am happy to be joined by Judge Mark Recktenwald, former Chief Justice of the Hawaii State Supreme Court. This week, we're talking about Hawaii's unique system for state judicial appointments and how Native Hawaiian culture and history shape its legal system today. We're also taking a look at new developments inside the Department of Justice and a new position they're taking on who gets to discipline federal prosecutors. If you don't already, make sure you hit like and subscribe, follow us wherever you get your podcasts, and of course, watch us on YouTube. All right. Thank you so much, Judge Recktenwald, and thank you for joining us on the podcast. It's a pleasure to have you here.
Brooke, thank you so much, and thanks for all the work you've done to focus on issues related to the rule of law and elections in our country. Super important stuff, and I'm very grateful to be here today.
My pleasure. And I'm excited to jump into some of those topics with you here today. So this is obviously your first time joining us here at Keepers of Our Republic. So I'd love to just hear a little bit about your background, specifically what inspired you to join the legal profession. How did you get your start?
Well, my father was a lawyer, which meant, of course, I didn't want to be a lawyer. So it took a long time to come around to that. But the key thing for me, I spent time in Washington, D.C. Around 1980, and the people who working on Capitol Hill, the people who I respected, the people who inspired me, were both journalists and lawyers. And there were folks who were doing very important work, investigating the 3 Mile Island nuclear plant accident, beginning to develop alternative energy, developing this Consumer Product Safety Commission. And so the committees and senator who I was working with were focused on issues like that. And it really caused me to think, journalism looks really interesting. And I did that for a year or two. And then I decided to try the law just because it would be a way to be able to have an impact, could really hopefully make society better for people and make our society more just and fair.
And what inspired you then to, because you've had a wide career in the legal profession, and I want to jump back to some of your experience as a U.S. attorney in a second here. But what inspired you to want to join the bench as opposed to continue in a straight legal practice?
I had been a law clerk right after law school. So I came back to Hawaii, where I'd been living and working as a reporter and working at our state legislature. I came back and I worked for a U.S. district judge named Harold Fong, watching him in court every day, watching the way he was able to, even through really small gestures of
Hmm.
sort of kindness, of compassion towards folks who really had no hope in their life, but by saying, you're only going to go to jail for 80 months instead of 84 months because I see some good in you, and here's what I see, kind of inspired me to think, that's that kind of impact and that kind of being, a gracious but still strong person who's applying the law is something that would be an amazing opportunity to have. So I kept it in the back of my mind, but it's not one of those things you can plan on. It just either it happens or it doesn't. And so I just kind of went off and lived my life. And fortunately, things came around to where I had that opportunity much later, though.
What is the Hawaiian system for how judges are appointed, elected, partisan versus nonpartisan? We had a really fascinating conversation with one of your colleagues, Tom Phillips, in our last episode where we talked about the Texas system for how judges are appointed. What is the Hawaiian system?
Well, ours is we call a completely merit-based system. So no elections, not either in the first instance to come to the bench or a retention election. So we have a nonpartisan commission with 9 members appointed by various government officials, and 2 of whom are elected by the bar. They screen candidates and make recommendations of 4 to 6 candidates, typically to the governor, to appoint for our appellate courts or our general jurisdiction trial courts, the courts that do jury trials, and then interestingly, to the Chief Justice for our specialty court, or our sort of more focus courts, what we call our district courts: traffic, misdemeanor crimes, TROs, family court. And so either the governor or the Chief Justice selects from that list, and then it goes to the Senate to be confirmed. So there is a political element to the process, but that element is in the process of confirmation. And then at the end of each judge's term, that same commission decides whether to retain them for another term or not. So
Interesting.
it's a system that was designed to leave input for the political branches. So some of the members on the commission are appointed by members of the legislature and the governor, but also to try to pick people without regard to their political backgrounds, and simply based on the merits of what they've accomplished so far in their career. So we're one of the purest examples of a merit-based selection system in the country.
Yeah, that's very distinct from other states, I know. When you talk to your colleagues or when you think about the more overt campaigning, political parties, donations that get wrapped up with judicial elections in other states, are you grateful for the Hawaiian system, or do you wish you'd had an opportunity to be out on the campaign trail?
Well, it's very interesting, and I'm not saying there's anything wrong with how anyone else chooses to do it. And I've had colleagues who I've talked from other states who've told me they enjoy getting out in the state. They enjoy going out and hearing what people think, and having to at least do this sort of grassroots campaigning. I don't think anybody particularly enjoys having to fundraise, and judges have to be insulated somewhat from the actual fundraising process. But for me, the issue of money and where the money comes from, and the potential effect on the judicial process, that was always the key for me. And I remember I had a mentor who had been the head of our Intermediate Court of Appeals, and who told me there's an association of judges, of the chief judges of the Intermediate Court of Appeals. He said, I went once and I really didn't care for it. All they were talking about is elections and raising money. And I was a new young kid on the block. I said, "Yeah, Jim, I hear you. Sure, sure, sure." So, of course, I went to the conference. The first night we were there, I went out to dinner with some judges from southeastern states, wonderful people, and almost immediately the conversation turned to a pending race in one of those states. And the sort of the conversation was, okay, so Joe, who's running against Jane, Joe has the timber industry, the railroad industry, and the chemical industry, and Jane has the trial lawyers, the insurance companies, and like the chemical companies. And just like hearing that, for me, it kind of, first of all, I realized my friend Jim was a really smart guy, and secondly, made me realize that, just especially as the amount of money has grown, it's very hard to insulate yourself from it. Although I will give credit to my colleagues in other states. The rules of judicial conduct try very hard to keep them one step away from actually soliciting funds, and have committees in between. But
Yeah.
for me personally, and for us in Hawaii, I think that sort of potential impact of money on the judicial process is not a good mix. That's just, again, my personal view, and
Yeah.
I respect my colleagues who have told me passionately they love going out there, going door to door in Missoula, Montana. And I kind of get that.
Yeah.
But there's a far cry from going door to door in Missoula to being in in Wisconsin, and having almost $100 million put into a Supreme Court race, which is a crazy amount of money
Yeah.
for a state of that size.
Yeah. Yeah, I have you talked about your state there, and some of the differences. I don't know where this question is going to go, but I'm so interested because I know very little about Hawaiian legal history. I grew up out west and went to law school out west, and we know that our legal system uh, is very affected by and is colored by the Western expansion movement, by Spanish colonization, by Mexican history, things like water law, and even marital asset distribution and property laws. It's very affected by our history. And then you think of places like Louisiana, which was, of course, colonized by the French. They've got a whole different thing going on in the Louisiana legal system. You know, Hawaii is obviously very unique in the American states. To what extent do you think Hawaii's unique history, like pre-colonization or pre-statehood, affects the Hawaiian legal system for those of us who aren't from the state?
It's a great question, Brooke, and it really touches upon some of the most significant developments in our legal history in recent years. So, of course, Hawaii used to be an independent nation and was taken over by or with the support of the United States government in 1893, and then was a territory and then became a republic before joining our nation as a state in 59. And at various points during that history, and particularly in the early 1900s, Hawaiian culture was often suppressed. Hawaiian language began to die out. But then in the 60s and into the 70s, there was a renaissance of pride in the Hawaiian people, pride in the culture of Hawaii. And in 1978, we had a constitutional convention which amended our constitution and incorporated those values in a variety of different ways, from protection, explicit protections for the environment, explicit protections for traditional and customary Hawaiian gathering rights, and that was a very, very significant development. And that really has been a big part of what my court has done over the last 50 years, is trying to give meaning to these very broad, bold, statements of who we are as a people and what we believe in. And meanwhile, there's a whole common law development led by one of my predecessors, William S. Richardson, who began to incorporate principles of Native Hawaiian traditional law into
Hmm.
our legal system. And the best example of that is access to the beaches. So he, based on principles of traditional Native Hawaiian law, basically, my court reached a decision that said people don't own the beach. You cannot own the beach. So everybody jointly owns the beach, and you only own up to the sort of to the water line or the high reach of the water line. And also a lot of decisions related to water rights, which of course here in Hawaii, that's a huge issue on any island. So we have a really interesting mix of traditional and customary laws that are very much part of our system in various ways. And we're very, very proud of our Constitution and have a very strong and dynamic view of that Constitution. Some states, they take the position that they are not going to go farther than the U.S. Constitution. They're going to move essentially in lockstep with how the United States Supreme Court defines their Constitution. And we've taken another path, which is to be much more active, both in interpreting the provisions unique to us and in interpreting provisions that have similar language. So that's something that, we've had very high profile decisions related to gun rights. We had another high profile decision related to the Establishment Clause. And these again reflect our views as a state and what we saw in our Constitution as a vibrant, sort of political entity that's going to think for itself based on its own history and values, of course, consistent with the U.S. Constitution. So it's a fascinating court to sit on.
It's so fascinating. Thank you for taking us a little into that history, because it's just a completely different lineage, a proud cultural history that you guys have in that state that is so distinct from anyone else we've had a chance to talk to. I want to turn now, before I get too ahead of myself, to kind of a totally different topic. And that is, you recently co-authored an opinion piece that appeared in, among, I think, a couple places, Bloomberg Law, talking about the Department of Justice and their new position on disciplinary proceedings for their attorneys. Can you walk us through, for those of us who didn't read the article, which of course I'm going to link in the show notes for this episode, but for those of us who aren't familiar with what's going on there, can you just kind of walk us through the background of this?
Yeah, it's a really important sort of tension between what the Department of Justice is trying to do and what states and the District of Columbia have historically done, which is regulate the legal profession. It goes back to the very beginning of our nation that lawyers, in essence, were admitted to practice and in some ways regulated by particular states. And historically, and a huge component that goes with that is that those states were the entities responsible for adopting disciplinary rules and then enforcing those rules with sanctions up to and including disbarment. And that's something that I believe every Supreme Court, a state Supreme Court across the country, it's a important part of what we do. You know, we would get a steady diet of cases, you know, ranging from lawyers who didn't handle client funds properly to, you know, lawyers who were accused of misrepresenting things to the court that we would handle and try to determine what the appropriate discipline was. So what I think is problematic in what the Justice Department did, and there's really two phases to it. First, there was a rulemaking where the department basically said if there is a complaint against a Department of Justice attorney, the state basically needs to defer to the Justice Department's internal review process to take the first cut at deciding what the appropriate way of handling that dispute is. And that's, you know, super problematic because I think while there may be times when the state would say, you know what, you go ahead, Department of Justice, you investigate your own lawyer. We'll stand by and see where you are at the end of that. There's going to be other cases where the state has a very strong interest in moving quickly. And I think the sort of unstated concern was that, you know, possibly there could be cases where the department would say, we've investigated this, we've determined there's no wrongdoing, and we declare this matter at a close. So that was sort of round one. There was a rule that's been out publicly, got a ton, like 1 million comments, I think overwhelmingly negative. And then the next thing that happened is there was a particular person who worked in the first Trump administration, who towards the end of the it was in the Department of Justice at a very high level, and who had advocated very, very strongly for the view that the election, particularly in Georgia, was improper, or there had been improper influences. And he was basically told by the top two, the acting attorney general, acting deputy attorney general, we have investigated this thoroughly. There's nothing there. And you know, we'll tell you, these are the folks you can talk to if you want to satisfy yourself to that, but there is nothing there and we're not going to pursue this matter further. He continued to pursue it, and it got to the point of actually coming to the attention of the president. To his credit, who eventually rejected the idea of sort of moving forward on the theory that this individual was pushing. But after all that happened, he was the subject of disciplinary proceedings in the District of Columbia, and which are now pending. Initially, there was a recommendation to suspend him for 2 years, and then that upon review, that was up to a disbarment, and now that's in front of the D.C. Court of Appeals, in essence, the highest court of the District of Columbia. So this lawsuit by the Department of Justice, not by this individual, by the Department of Justice, basically seeks to stop that ethics inquiry, and really would cast a very, very large shadow, and basically said, we will regulate and ensure that our lawyers are ethical to our own standards, and we do not need nor do we welcome the help of the states in doing that. And again, that's a fundamental reordering of the sort of system that's existed for, you know, almost 250 years.
Yeah, that's fascinating. And, you know, as a Washingtonian personally, you know, there's a real tension right now between the district and federal, and the very unique system that we have as a district, not a state. And I know within the district here that tension is always simmering underneath the surface of certain things. Thanks for sharing that with us. And it's not something that I'd seen widely covered in the news, and so I'm glad it's getting some attention. Admittedly, we are filming this right now, the week of some major Supreme Court decisions being handed down. So it's a busy season. It's a busy season for legal news at the particular moment.
But, you know, let me just say, Brooke, you know, for a judge, you rely on the ethical conduct of the lawyers who appear before you. It's an adversarial system. You rely on folks to make representations to you that are accurate. You rely on lawyers to be aware of and follow the codes of professional responsibility. So that's really foundational to our system. And, you know, to have multiple checks on what attorneys can do, I totally understand the department wanting to hold its folks to a high standard. I used to be an assistant U.S. attorney, and so I was very aware that there was an Office of Professional Responsibility in the department that was waiting to hold folks accountable. But the key is you're always licensed by a state jurisdiction. You're licensed by a state or the district, and you need to be accountable to that jurisdiction's code of conduct. And that's a really important check. And so that was something in the early days of the administration. I really noticed, when there were issues about alleged misrepresentations being made to courts, that the plane had taken off to El Salvador already. There was nothing I could do, Your Honor. And those are things that classically United States district judges take very, very seriously, and they are very, very careful to make sure that they're not being told incorrect information, because they have to rely so much, especially on government lawyers. And that's why there's sort of each time something like this happens, it undercuts what they call a presumption of regularity for the United States. And that, for me, it cut, I've been on both sides as a Supreme Court justice and as an assistant U.S. attorney. And it really dismays me to see the trust that had built up over decades or centuries of the Department of Justice lawyers appearing in court and being folks who the court could count on to tell it the truth has eroded.
Yeah. Let's talk about some of the other challenges facing the judiciary right now. What do you see, perhaps even more uniquely from a state perspective, but just in general, as being some of the biggest threats and challenges that our judiciary is facing at this moment?
Well, there's a whole range of them. Obviously, threats to the safety and security of judges, and, more to the point, folks who come into the courthouse. And I think sometimes, maybe people say, well, that's just the judges, they're whining because about themselves. Well, the reality is, some of these attacks take place at courthouses. People show up at courthouses and, looking to find the judge, and, there's other innocent folks there. And so it's really an issue for everyone. And the number of threats and actual incidents of assault or worse has, I think, gone up like tenfold over the last decade or so, both on the federal side and on the state side. And I think, clearly the rhetoric that has elevated in the last year, the sort of demonizing judges, personalizing them as bad people for their rulings, all fuels that. So that's something that I think both state and federal judges are very, very aware of. And if anything, it's more of an issue in state courts because, federal courts typically are in big federal courthouses with a lot of U.S. Marshals that have been very well, developed for security. I mean, states have, little bitty courthouses out in the middle of, wherever, and trying to secure those courthouses can be a real challenge. So that's one issue. I think challenges to the legitimacy of the judicial process, to this, suggestions that judges just rule the way they do because they're partisan, because they have political beliefs, I think are ultimately very corrosive to respect for the rule of law. The suggestion that, maybe I just won't follow that decision if I don't feel like following that decision. I think, again, for an ordinary citizen who hears that, I think it tends to erode the faith that maybe they had in the system, which I think the beauty of our system is, I think people believe that the courts they absolutely understand they're not perfect. They're not going to always reach the right result, but they fundamentally believe they're going to get a fair shake when they come to a federal or state court in the United States. And as disappointed as they might be, they will accept that result and move forward with their lives for, the vast majority of folks. But when they see somebody very powerful basically saying, "No, I'm not going to, I'm just going to go ahead and keep doing what I was doing." I think that has an effect of undercutting the courts. And the other thing is just the way in which the bar has been subject to the executive orders that in essence punished law firms who took positions or clients that were disfavored by the administration. That affects courts because we do rely on the lawyers to come forward and advocate for the cases. And the better the lawyer, the better the advocacy, the better the outcome from the point of view of the court. And so I think that is something that really is concerning to me as well. So there's a lot of different ways in which I think we need to stand up for the independence of judges in general and the legal profession.
Yeah. And of course, it's not just you alone saying this. You have a number of colleagues who have been speaking out about these issues that we've been able to interview. Keep Our Republic has recently formed or helped to co-found the Alliance of Former Chief Justices, of which you are a proud member, and which is how we were able to connect. Any thoughts or messages you have for your colleagues at state Supreme Courts or who are currently sitting on state benches that you would like to offer in these, very, very difficult, uncertain times right now?
Well, the thing for me, again, the executive orders that targeted law firms were a critical moment for me. I was still sitting as a Supreme Court justice at that time, and I was very concerned about the effect on the system. And I sort of began calling folks I knew just to say, what's being done? Who's speaking out? Who's going to have something to say about this? And ultimately, different lawyers of some former judges came out and submitted amicus briefs, and so the position was ultimately argued in front of the courts that these executive orders were very, very, very corrosive to our democracy. But that sort of raised to me the notion and really highlighted the notion that as a sitting judge, I had strict limits on my ability to speak on issues that could in any way be perceived as partisan. And so this is sort of I guess you could call it a gray area. When we're encouraged to speak up in support of judicial independence and the rule of law to educate the public, but when we do that in a way that might be viewed as critical of a particular political party or person, have we strayed into,
Right.
unauthorized political conduct? So to me, when I did retire and found out that some of my colleagues had already started the process of forming the alliance, I was all in right away. And I think, the message to those who are still serving is, we have this group that does speak up. We're nonpartisan. We're not here to elect a particular candidate. We're here to stand up for the rule of law and point out why it matters and help educate people as to why it's important. Now, the one other thing I will say is I worked on a law review article that I hope will come out by the end of the summer, where I advocate that sitting judges should have a little more flexibility to speak out in response to challenges to the rule of law. And one thing I'm thinking of there is very, very early in the second Trump administration, the president criticized Judge Boasberg in the District of Columbia in very harsh, explicit terms for a ruling he made regarding the return of folks to, I believe it was El Salvador. It was a case I alluded to earlier, and calling for his impeachment. This judge should be impeached. And Chief Justice Roberts, to his credit, issued a statement a few hours later that it didn't mention the president by name, but very clearly was referring to his remarks, and in essence said, the proper way to challenge a ruling that you disagree with is through appeal. It's not to threaten that judge with impeachment. And to me, that recognized that there is a way in which judges can and should be able to speak, that defends the rule of law without making them openly partisan. And so I've tried to kind of look at what he said there and what other folks have done and try to create a set of principles that gives judges a little more flexibility to be able to speak without fear of being subject to judicial discipline complaints, because we have a disciplinary system too. And some judges have been subject to those complaints. And so I think we need to give them a little more clarity. I think judges should be able to speak up for the system. To me, a judge ought to be able to say, it's wrong, or we should not punish lawyers for who they represent or the positions they argue, as long as those positions are ethically sound and supportable by the law and the facts. The fact that they are distasteful to people in power should not be a reason to punish those lawyers. I think that's fundamental to the integrity and health of our judicial system. So I think judges ought to, at a minimum, be able to speak about those particular challenges, and even do so in a way that I think somebody who's paying attention would understand it probably relates to current events, without making an explicitly partisan back and forth between a judge and the president of the United States, which I don't think serves either one of their interests.
Yeah. Well, Judge, thank you so much for joining us today. It was such a pleasure to get to know you, to talk about your beautiful state and some of the different legal background that you have, and all the ways that make your state so interesting to us mainlanders. But thank you for joining us. I look forward to more of these conversations. And of course, thank you for your work with the Alliance. I know we'll be hearing more from you and your colleagues in the coming months as that grows. Thank you so much.
I appreciate it. And I appreciate what you've done with this series, and appreciate the opportunity to being able to share a little bit about my own journey and about the work being done by my colleagues here in Hawaii and across the nation in support of our Constitution. So thank you so much.
My pleasure. We appreciate you guys. Thank you so much again for joining us on Keepers of Our Republic. Don't forget to like and follow us, and I will see you next week for another one of these conversations.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.